A will is a way of saying in advance what you want done after your death. And so again, it's a way of being able to plan for the future and maintain some sort of direction and control to ensure that things happen the way you would want them to happen. In cases where someone may be a victim of abuse or neglect, that can be really helpful because there may be people they explicitly don't want to inherit or don't want to have decision-making authority about the disbursement of their estate. And so it's important to put that into a will, because if it's a spouse or a child and there's no will, the state will just assume that that person has authority to make those decisions and to inherit. So again, it's a way of sort of continuing to drive for a little bit after you've lost the power to make those decisions for yourself.
How about any unintended consequences? So are there any situations in which a will, a document, a legal writing of some sort could be used against an older victim?
Absolutely. There are definitely risks and benefits associated with all of these documents, because you are granting someone else authority to make decisions for you, legal authority to make decisions for you. And if that's someone that you trust and someone who's worthy of that trust, then that's a really helpful tool for you to plan your life and to plan for eventualities of incapacity or death. But if it's someone who is not trustworthy, then that gives them authority to make decisions that could be harmful to you.
There definitely are a number of legal documents that can be valuable for older survivors to either have access to if they already exist, or to take steps to get created. So certainly estate planning, which estate planning is a broad term that includes what will happen to my property after I pass. But it can also include, what do I want to happen if I become incapacitated? What kind of healthcare directives do I want to give in advance? And I think sometimes, I know for me personally, I didn't feel any need to have a will until I had a child. And then suddenly I was very worried about, if something happened to me, who would be in charge of my children. But if you're working with an older adult, they may not be concerned about their minor children, but they do have concerns about what should happen to them if they become incapacitated. If the law would make their abusive spouse their decision maker, should they suddenly go into the hospital, that might be unacceptable. And they can take action to change that and give a different set of directions. So that's a good example of what somebody might want. Power of attorney has come up. That can be a very useful document for people to think through and complete. Do I want to name the person that I would feel most comfortable having making legal decisions for me?
Are there any ways that these documents could be used against victims of elder abuse?
So I think that when you are a survivor of abuse, you are always managing risk, and there is always the risk that if you begin doing estate planning and choosing who your power of attorney is, or choosing who makes decisions for you, or choosing who gets your assets, that there's the risk that the people in your life who are abusive may start to abuse you around what you choose, right? So it could get used against somebody, that they get manipulated or coerced into giving an adult child power of attorney, but that adult child is actually abusive towards them. And sometimes there might be an attempt by that holder of power to interfere with somebody getting help.